What is a patent attorney versus a patent litigator? You may have also heard the terms patent litigation and patent prosecution. This video is going to give you all the answers on what these terms are and who these people are, so stick around. So if you're new to the channel, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used worldwide by inventors, entrepreneurs, and startups, including in top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit with Marcus Lemonis. So, patent litigation and patent attorneys, patent prosecution, litigation, what are all these things? It's kind of confusing, and in a lot of ways, I don't like using some of these terms because they are inherently confusing and really kind of don't speak to what these things are. So let's first talk about a patent litigator versus a patent attorney. So like I said, I'm a patent attorney. So patent attorneys, the focus of their practice tends to be on representing clients before the United States Patent and Trademark Office when it comes to drafting patent applications and filing them at the USPTO and working those patent applications through the examination process. So to be called a patent attorney, a person must be an attorney. They have to have passed the bar in at least one state, and they also have to have passed what's called the patent bar. It is a special bar at the USPTO which allows attorneys to then represent folks before the USPTO in the examination process. So a patent attorney has to have a technical background. To even be able to sit for the patent bar, you have to have a technical background in something like computer science, electrical engineering, math, physics, some sort of engineering, like even mechanical engineering. There has to be some sort of technical background because patent attorneys, they have to understand the inventions of their clients as well, if not better than those folks. Okay, so that's what a patent attorney is. Not every patent attorney is going to focus on that, and sometimes there is an overlap between patent attorneys and patent litigators, but I'll kind of get into that later. So a patent litigator, patent litigation is going to be related to the enforcement and defense against patent lawsuits. So a patent lawsuit, a litigator would file a patent lawsuit against somebody who is potentially infringing an issued and enforceable patent. So patent litigation relates to only issued patents, and it relates to activities that people are actually doing. So if somebody has to be making, using, selling, offering to sell, or importing a patented device or performing a patented process to be actually potentially infringing something, okay? It's not, hey, you file a patent application and that prior art of somebody else reads on that. That's totally different. That is patentability versus infringement. So infringement with litigation, that's all lawsuits, okay? So patent litigators, sometimes those people are patent attorneys, but I would say most of the time, patent litigators, they are just plain attorneys. They may or may not have a technical background, and most of the time they haven't passed that special patent bar. But that's not required for patent litigation because patent litigation is going to be in courts of law. It's going to be in federal courts. So you just need to be an attorney and then you can do patent litigation. So a lot of times, yeah, technology is going to be the core of patent litigation, but a patent litigator, their focus is the litigation process, which is a very specialized practice of law. So for me, I've done some patent litigation, but am I specialized in that? Absolutely not. I am not great at that. Somebody who is a litigator, they know the ins and outs of the court system. They know about complaints. They know about the pleadings. They know how to argue things in court. They know about the judicial process. For me, as a patent attorney, the last time I went to court was when I was actually sworn in as an attorney. Like, I don't really do court stuff. There was a time when my practice involved more patent litigation, but that was more as a consultant to a patent litigator. And like I said, oftentimes these are folks who, they are attorneys who focus on litigation and happen to focus on litigation involving patents, but they don't have a technical background and they haven't passed the patent bar. That's not what they do. Their focus is on litigation. So some other terms that are important to understand is litigation versus infringement versus patentability. And this gets people confused. Also, the term patent prosecution gets people confused. So patent prosecution sounds like patent litigation, But patent prosecution is the process of drafting and filing patent applications and working them through the examination process. Again, litigation is filing lawsuits or defending against patent lawsuits. That's why I don't really like to use the term patent prosecution, because it sounds too much like litigation and it really confuses people. I tend to like to say the patent examination process versus patent litigation. That makes a lot more sense to folks. So let's talk about another issue, which is the difference between infringement and patentability. So we've talked about infringement. That relates to patent lawsuits, which is completely different than patentability. So people think, oh, okay, I filed a patent application and that could infringe on other people's patent applications. That's not what infringement is. And when people talk about infringing on somebody else's patent application, what they're thinking about is the issues of patentability. So let me step back and talk about the examination process. So you file a patent application, the patent examiner will do a patent search and determine whether the claimed invention is new and non-obvious compared to the prior art. That's the analysis of patentability. It doesn't relate to infringement. Infringement, again, relates to issued and enforceable patents. So when it comes to patentability, patentability can relate to any sort of technology disclosure. Sure, one type of prior art is an issued patent, but also pending patent applications, the publications of those, that can be used as prior art, and that can be used as prior art regardless of whether that patent has issued, whether that patent ever will issue, or even if it went abandoned. A publication that then went abandoned, that can still be used as prior art against a patent application. That's one of the main things that is different about patentability versus infringement. Okay, so other sorts of prior art can be used. Prior art, things like scientific papers, blog posts, videos like YouTube videos like this. I've had YouTube videos used against me as prior art in the examination process. So that's another important thing when it comes to infringement versus patentability. Patentability relates to any technology disclosures, but it's technology disclosures that occurred before you filed your patent application. And the determination made by the examiner is what you have claimed, is it new and non-obvious compared to that prior art that came before when the patent application was filed. Okay, so that is the difference between patent litigation and patent prosecution, or the examination process, and patent litigators versus patent attorneys. I'd love to hear your comments down below. Let me know if this all made sense, if you have any additional questions. And yeah, thanks for watching, really appreciate it. Be sure to subscribe, click that little bell icon for more information about patents and startups, and we will see you again in the next video. Thanks for watching.